Okay, that's brilliant. So welcome everybody to this next session of our virtual participation conference. Like many of the others, this session will be recorded, so do turn your camera off if you want to. I'm Kate from Contact, and I'm here to introduce the IPSEA Send Law session with Kate Cox, a member of the legal team at IPSEA. So welcome, Kate. Thank you.
Thanks, Kate. So hello, everyone. It's really lovely to see so many of you joining us today, especially on a day when I imagine for some people it might be a bit tricky potentially to organise it, what with the strike. So thank you, I do really appreciate it. And thank you for allowing me to join your workshop. So as Kate mentioned, my name is also Kate. I am part of the legal team at IPSEA. I'm a non-practicing solicitor, so I trained in London, and I'm also a parent of children with SEND. So it's really great to be with you today. Okay, so we are going to be looking at where we can find some of the main sources of law that relate to SEND, and we're also going to look at routes of redress, so what we can do when things don't go to plan. So in this workshop, which should last for about an hour, we're going to be covering the following. We're going to run through an introduction to IPSEA, so those who might not know of us. I'm then going to lead us on to where we can find those key sources of SEND law, looking at regulations, statutory guidance, and some case law. This might sound a bit dry, but at IPSEA, we really know that if we know where to find the legal rights that children and young people with SEND have, then we are able to put these in place and hold decision makers to account if they're not. Hopefully, it'll be more interesting than maybe it initially sounds. We'll then think about what parents and carers can do if issues arise. We know all too well how often these can, and I'll also let you know where you can access training on SEND law to help build up your knowledge. Then we're going to think about what might come next in terms of the SEND review. And then lastly, I'll be happy to take any questions you have at the end. So if anything's not clear as you go through, let either me or Sue know. But if we can hold off asking the questions until the end of the presentation, that'd be great. As Kate mentioned, this session is being recorded, so you don't need to worry about writing everything down. You'll be able to access the recording, and you'll also receive a copy of my slides. As it's being recorded, if you're going to ask questions, please remember to keep personal information out of the discussion. And bear in mind, I won't be able to answer personal questions relating to your children or young people, because I don't have all the facts, but you are welcome always, of course, to make use of our free advice lines, and details of that are coming up. Okay, let's look at who IPSEA are for anyone who doesn't know. So I always describe us as a small but mighty charity. We offer free support and SEND law to more than 4,000 parents, carers and young people a year. Anyone can access our resources on our website, and we work hard to drive up more lawful decision making by offering training to those able to influence children and young people's lives. So we train schools, local authorities, other professionals, and our training regularly sells out. It's in really high demand. We also help parents and carers understand what rights their children and young people have. We know that with knowledge comes power, and parents and carers are better able to enforce these rights when they know of them and how they function. We have a team of highly trained volunteers who help take calls on our helplines, and all those volunteers are supported by myself and members of our legal team who are always on hand through supervision, monitoring and assistance. Our training courses remain hugely popular. Parents and carers often feedback that after one of our training sessions, they feel so much more confident to ask for what their child is entitled to. We also know that the training we provide to local authorities and schools is highly beneficial from the feedback we receive. We're always looking to go one step further there at IPSEA, and we work really hard on the policy work. We're ideally suited to help drive through policy reform by combining all of our legal expertise and knowledge we've gained from experiences that parents and carers share with us. So that was who we are. I just thought it would be useful to let you know we do run a bespoke parent carer forum training. When you receive these slides, you'll be able to click on the hyperlinks. So if you're interested in that, you'd be more than welcome. And we run regular parent carer training sessions as well. So there's a few of the dates of ones coming up. Okay. So Just a brief overview of some experiences that parents and carers share with us. The range is really big, but here are some of the top topics. When we look at the website data for the second half of 2022 and our helpline call data, we see a range of issues parents and carers are looking for support on. Many parents come to us needing help requesting EHC needs assessments, for which we have a model letter on our website, model letter 1, anyone who would like to use it, and what they can do if their request is refused. As some of you may know, having an EHC needs assessment carried out is the first step towards getting an EHC plan in place. So we understand how vital it is that these assessments are carried out when the law requires them to be. And we're going to go on to talk about that shortly. We know lots of families need support on the context of EHC plans, and when those plans are not being properly implemented or issued on time by the local authority. The law around naming a school with an EHC plan comes up as a key topic for parents and carers, and our web pages, model letters and helpline calls all help deal with this. We also see a lot of issues around annual review in terms of the legal process not being followed and amended plans either not being issued or not issued on time. For any of you who this might be relevant, we have phased transfer deadlines coming up. 15th of Feb for most, or the 31st of March if your child is moving from school to post-16 education. Just so I flag that now. Okay. So we are going to look at where we can find the requirements and duties on local authorities and schools, and what rights young children and what rights children and young people are entitled to. When you receive these slides, you'll see all of the references of law here are hyperlinked, so you'll be able to go through them and find some of the sections we're going to go on to talk about. Every child deserves an education which meets their needs, and children and young people SEND are included in that. The law I'm going to go on to talk about now is an opportunity to level the playing field and ensure their needs are met. The law is not trying to give children with SEND anything fancy or anything extra, but that to which they are entitled to. Their opportunity to thrive and succeed in all the ways they're able to must be valued and supported, and SEND law properly implemented safeguards this opportunity. The main sources of SEND law are what's known as the Children and Families Act, which sometimes we abbreviate to CAFA, but Children and Families Act. And this sits together with the Special Educational Needs and Disability Regulations 2014, which I'm going to refer to as the SEND regs as we go on. I'm going to talk very briefly about some social care legislation. There's a range of healthcare legislation. I'm not going to go into that in detail today, but the two bits of social care legislation I'm going to highlight today are the Chronically Sick and Disabled Persons Act, as well as the 1989 Children Act. We're going to have a little think about case law, and that's the decisions that are made in the tribunals and how they affect the law. And we're also going to consider the 2015 Code of Practice. We're not going to be looking at local authority policy. That's not law. To the extent local authority policy doesn't comply with the law or introduces new hurdles and thresholds, then it's invalid. A top tip for when you're looking at these sources of law is to make sure you're looking at it as the latest version available. All the links I've given you will take you to the latest version available. But if you're searching for a source of law, through Google or something, on the left-hand side, you can see it as originally made or latest version, and it's the latest version you want because then it will include any amendments that are being made to the law. Okay, so we're going to look first of all at the Children and Families Act 2014. This uses a person-centered approach. It has some guiding principles in section 19, and these have been described as enshrining a culture of change in the way that children and young people who have or may have SEND are supported. These should put them and their families at the heart of a holistic evaluation of their needs, what those needs might require, and ensure that aspirational outcomes are kept in mind. The Children and Families Act is where we find many of the key definitions and duties. I'm going to run through some of them now because I'm sure that they'll be relevant for many of your children. The definition of special educational needs is found in section 20. And we can find the definition of special educational provision in section 21. These are really important definitions. If you can understand these, then they are key to accessing SEND support at school or for making an EHC needs assessment request, for example. So that's section 20 for the definition of special educational needs, 21 for the definition of special educational provision. The reason this is important because, for example, the test for when an EHC needs assessment must be carried out is also in the Children and Families Act. We find that at section 36. This section tells us what EHC needs assessment is, when it must be carried out, and what things the local authority must consider when making a decision on it, such as the views of parents or young people themselves, and whether any additional time is required to finish educational training in the case of a young person who's over 18. Other key sections in the Children and Families Act are 37. This tells us what an EHC plan is and when it must be issued for a child or young person. Remember that test in section 37, for those who don't know, it's if a plan is necessary. Section 42 is also key. Section 42 of the Children and Families Act says that once a EHC plan is finalised, it must be maintained as an absolute duty. We're going to go on later to talk about what you can do if a plan is not being properly implemented, but it's section 42, which is the bit of law that's really useful to know. It's the bit that parents can use to enforce plans. Section 38 tells us about the duties on local authorities regarding draft plans, and that includes that important right for parents, carers and young people to comment on the draft plan and ask for a particular setting to be detailed in section I. This setting must be named unless exceptions in section 39(4) apply. So it's really beneficial for parents and carers to know where to go to find that right. We've got lots of information on our website about it as well. EHC plans need to reflect children and young people as they travel on their educational journey. And section 44 sets out when plans need to be reviewed, as well as when needs need to be reassessed. Again, if you're aware of where you can find these rights, then you can help ensure that legal duties are met. Lastly, just on this section, section 51, these set out your rights to appeal. And section 55 says when you need to consider mediation. So, like I say, underneath the Children and Families Act, we have the SEND regulations. And it helps to think about them as kind of applying flesh to the bones, if you like. So it's where we find lots of the detail. For example, I mentioned section 36 says what an EHC needs assessment is and when it needs to be carried out, but it doesn't tell us how. And we find that in these regulations, specifically regulation 6. And this says who the local authority has to contact and what advice they need to obtain. For those who might not know, they need to obtain information and advice on needs, provision, and outcomes. We find that in these regulations. Knowing this allows a parent or carer to make sure the process is being properly followed for your child. It's also really important because at the end of an EHC needs assessment, a decision will be made as to whether or not an EHC plan is necessary. So if the EHC needs assessment has not been properly followed out, you might not have gathered all the information that you require for that decision to be made. The local authority must consider all the information it obtains during an EHC needs assessment. That's in regulation 7. And it needs to consider this when drafting out plans. And that's a legal duty in regulation 11. We also find many of the legal timescales and deadlines in the SEND regs. So for example, regulation 5, that tells you that the local authority needs to make a decision about whether it's going to carry out an EHC needs assessment. And it needs to tell you within 6 weeks maximum for the date of the request. So if you make a request for an EHC needs assessment, the local authority needs to tell you as soon as possible, but hard stop 6 weeks from the date of that request. So if it's not done, then you know you can complain. Regulation 8, this tells us when the information sought during an EHC needs assessment needs to be returned back to the local authority. And again, we have a 6-week deadline here, and there's some limited exceptions apply. Regulation 10, this tells parents and carers that if a local authority decides an EHC plan is not going to be issued, they have a maximum of 16 weeks to tell you. Regulations 12 and 13 are key. because they include an important duty of specification. They tell us how long local authorities must give parents and carers to comment on a plan. You must have at least 15 days to make any comments on a draft EHC plan. And they also contain that long stop deadline of when an EHC plan needs to be finally issued. And that's where we see the 20-week deadline come from. So from the date a request is made for an EHC needs assessment, then EHC plans must be finalised within a maximum of 20 weeks from the making that request. So again, if it's late, you know you can look at those regulations and you can complain because those are legal duties. Okay, I'm not going to go into huge detail on social care legislation, partly because it won't be appropriate to everybody on this workshop today, but there are a few sources of law which are useful to flag. Partly because social care provision can form part of an EHC plan in section H. So this could include things like respite, help with basic needs in the home, physical adaptations, for example, to the home. And it's also, it's also really useful if you can think about any health or social care provision which educates or trains a child or young person, because that's classified as special educational provision and it would go in section F. Okay, so on top of the legislation and regulations I've just talked about, we've also got case law. All cases about SEND that go to the tribunal are heard first of all in the SEND tribunal, or you might know of it as the first tier tribunal. Sometimes these cases go on to be appealed in the upper tribunal if there's a point of law that needs addressing. And those cases that go to the upper tribunal create what's known as a binding precedent. So those cases apply to the lower courts, the SEND tribunal, and also to the local authority. And they can be really helpful if you are, for example, facing a local authority telling you that an EHC plan isn't necessary and therefore won't be issued. You can look at some of the case law we have on our website that talks about what that meaning of necessary is. So when might a plan be necessary? You can find these case law on our website, but also the Noddy Guide. It's a really user-friendly tool for anyone who doesn't know of it to find details about SEND law and case law. So there'll be a link in your pack to the Noddy Guide, and I do suggest you you have a good look around it. It's really helpful. Okay, lastly then, the code of practice. It's statutory guidance, so it's not legislation, but there is a need to have regard to it. So let's think about who might need to have regard to it. Well, that'd be local authorities, all local authority funded early year providers, schools, colleges, although not wholly independent ones. The SEND tribunal needs to have regard to it, NHS trusts, social care teams. So it's a wide group of people who need to have regard to the code of practice. If they're going to depart from it, they'll need to say why and show good reason. So some useful sections I just wanted to flag in the code to you now. I thought everyone might quite like this one, paragraph 1.13. And this says that local authorities are actively encouraged to work with established parent-carer forums. Chapter 5 deals with early years. So for any of you who have young children, there's lots of guidance in there. For example, paragraph 5.4, which says that providers need to have arrangements in place to support those with SEND. And 5.6 is an important duty. Local authority controlled nurseries need to do everything they can to make sure children with SEND get the support they need. They also need to have a SEND code and include these children in activities. Chapter 6 deals with schools, and we see lots of useful statutory guidance here, especially in relation to SEND support and the graduated cycle that's talked about in the code of practice. You can find that from paragraph 6.44 onwards, if it's useful for you. So the code of practice here talks about identifying SEN. It makes clear that attainment in line with chronological age, for example, doesn't mean there isn't a learning difficulty or disability. That's in paragraph 6.23. It says that schools should consider involving specialists when a pupil continues to make less than expected progress. You'd find that in 6.58. And it goes on to say that specialists can be involved at any point, but schools should always be involving them when a pupil continues to make little or no progress, or where they continue to work at levels much lower than their peers despite support in place. And you could find that it's 6.59. That's 6.59. Anyone who might need to request an EHC needs assessment, there's lots of information from paragraph 6.63. Chapter 7, now this deals with further education. One useful paragraph I'm just going to highlight here is 7.3. And this lists all the statutory duties on post-16 settings, including doing all they can to make sure that the special educational provision which is needed is put in place. Chapter 9 deals all about EHC needs assessments and plans, and gives some really good examples actually to some of the things we were just talking about. Paragraph 9.35, this says that where particular services are identified as being required, such as resulting from statutory social care assessments under the Children Act, then this provision should be delivered in line with the statutory guidance and should not be delayed until an EHC plan is complete. So that tells us that if a child is in need of those services and there's a delay with the EHC plan, maybe the local authority hasn't issued it on time, then those services should still be being provided. It also tells us at 9.39 that the process of an EHC needs assessment and an EHC plan development needs to be carried out in a timely manner. So although there are maximum deadlines in the regulations, steps must be completed as soon as practical. And that might be really important for a family, depending on their child or young person's situation, because it might be really critical that that support is put in place. So one other point I just want to flag to you from the Code of Practice is 9.56. One of the things we see at IPSEA quite often is that when an EHC needs assessment is carried out, sometimes the information sought from professionals could be clearer. 9.51, the Code of Practice, is quite helpful because it tells us that the evidence and advice that's being submitted to the local authority should be clear, accessible, and specific. It should provide advice about outcomes relating to the child or young person, as well as any provision that they consider the child or young person that might be required. So quite often, if we have a parent or carer who has a report which actually doesn't give them that much detail, sometimes we'll recommend that they go back to that expert, reminding them of their duties under the Code of Practice at 9.51, and that the information needs to be clear, accessible, and specific to see if there's any modifications that they need to make to their reports. Okay, so a little quiz. No need to answer out loud, just have a think about the questions here. I'll give you some time to take a moment, and then we will go through the answers. Okay, so where would we find the definition of special educational needs? We talked about that. It's at section 20 of the Children and Families Act. The process for an EHC needs assessment, we find that in the SEND regulations, regulation 6 we talked about. And then lastly, can a local authority apply a higher threshold in its policies? No, it's the law that applies, and local authority policies must comply with it. A higher threshold wouldn't be valid. So that's where we find the rights and duties. Now we're going to look at what we can do if we need to enforce them. Unfortunately, we know that many children and young people SEND are not given the support that they need and are legally entitled to. We know there are very high numbers of appeals being heard currently. And we also know that a significant majority of those appeals are heard in favour of parents and carers, not based on any bias or preference in the tribunal, but on the application of evidence to the legal tests. Unfortunately, that shows us that unlawful decision-making is rife. So what can we do? Well, there are a number of options open to parents and carers, but which one to take will depend on what the issue is about and whether there are any other options available. Here, I've listed some of the formal routes a parent or carer can take, as well as the considerations we need to make when deciding what route to take. We're going to look into them in a bit more detail now. Okay, so we're going to look at making complaints first. This might be the first place to start when we face a challenge, and it might resolve matters quickly. It might be appropriate to use a complaint, for example, if a local authority has missed a legal deadline, such as not telling a parent carer within 6 weeks whether or not it's going to carry out an EHC needs assessment. Most local authorities will use a two-stage process. We always advise families to follow this system, and at the same time, consider complaining to a senior member of the local authority, such as the Director of Children's Services. Details of our model complaint letters and how to complain are all on our website, and I've given you a hyperlink here on the complaining to local authority section. If that doesn't resolve the matter, or maybe the local authority hasn't responded in a reasonable time, then you might need to escalate the matter to the local government and social care ombudsman, also known as the LGSCO. They think that 12 weeks is a reasonable time to wait for a response. If you waited for longer than that, you might not need to wait for the local authority to finalise its resolution process. You can't complain to the local authority, to the local government or social care ombudsman about everything though. The LGSCO won't hear matters if you could appeal to the SEND Tribunal. So if you've got an alternative route, they're not able to investigate. And they're only able to investigate when these two things have happened. First, there needs to be a process which should have been followed and wasn't, or maybe that process was carried out poorly. So this could cover things like where the help in section F of an EHC plan, that special education provision, has not been provided, or it could be where the local authority stops providing transport suddenly. Next, the LGSCO will need to see that injustice was caused as a result. So in the examples I just gave, it could be that section F wasn't being implemented and the child or young person was going without their special educational provision. Or in the case of the transport I just mentioned, it might be that the child is unable to attend school after transport was removed, or only at cost to their parent. So if there's been a fault but no injustice, the local government social care ombudsman won't be able to make a recommendation, as a remedy wouldn't be needed. The LGSCO will investigate every complaint it receives, and it aims to assess all complaints within 28 calendar days. After their initial assessment, they'll then go on to decide whether or not to do a full investigation of the complaint. It aims to complete all its investigations within 26 weeks, although it can take longer in some more complex cases. And after the investigation, they will issue a decision, and they can make recommendations to a local authority. And these are so they can put right the injustice. They are only recommendations, so they're not binding on a local authority in the same way that, for example, a court order would be. But in our experience, it's quite rare for a local authority to ignore a recommendation. Now, you might have a matter which is urgent, and waiting for the LGSCO wouldn't be appropriate. Or maybe a recommendation is not what you need. Maybe you need a binding court order to force a local authority to do or to stop doing something, or maybe to provide some temporary relief. You can apply for a process called judicial review if you think a decision was made which was not fair, lawful, and reasonable. If it relates to SEND, you'll need to show either that the local authority didn't have the legal power to make the decision it did, or to take the action that you object to, or you'll need to show that the local authority is under a legal duty to act or make a decision in a certain way and is refusing or failing to do so. This could include, for example, a failure to secure provision under an EHC plan, or a failure to put in place temporary education under Section 19 of the Education Act, 1996. IPSEA doesn't advise parents and carers on judicial review, and we would recommend you always check to see if you're eligible for legal aid. Generally, you'll need to show you've done everything possible to try and resolve the matter, and you will need to apply as soon as you can, but within the latest of 3 months from the date of the matter happening. So even if the complaints process hasn't been formalised or finished with your local authority, you've got a hard stop deadline of 3 months to make your judicial review application. It's a two-stage process. A letter before action is sent, setting out the problem and giving a local authority time to resolve it. If that hasn't worked, then court proceedings are issued. A letter before action can be really effective. Most local authorities are quite good at complying with letters before action, and you may find it a useful route to take if you needed it. So next we're going to look at what you can do if you have what's known as an appealable decision. So you can appeal to the SEND tribunal if one or more of the following has happened. A refusal by a local authority to carry out an EHC needs assessment or a reassessment. A refusal to issue an EHC plan after assessment. You can also appeal if your local authority has issued an EHC plan, but you're unhappy with sections B, that's special educational needs, section F, which deals with provision, and or section I, and that's where we see the name or type of setting. You could also appeal after annual review if your local authority has either refused to amend the plan or has amended it and you're not happy with those sections we just talked about, or if your local authority has said it will stop the plan. That's known as cease to maintain. You have a right to mediation whenever one of those things happens. Even if you only disagree with section I, you'll need to consider mediation in all those situations except section I appeals only. So if you're just unhappy with section I and you want to submit an appeal on that basis, you don't need to consider mediation and get a mediation certificate, but you are still entitled to it if you'd like to carry it out. Mediation is a free service for parents and carers to use. The local authority must arrange it if you've said you want it. You can take a supporter with you, including a legal representative, and SEND Regulation 37 is really helpful here. This says the local authority's representative who attends the mediation must be able to make decisions and have decision-making authority. So it wouldn't be appropriate for someone from the local authority to turn up who said they were going to have to go back to panel to make a decision, or to take the matter up to their senior leadership team. The person who attends mediation needs to be able to make decisions in that mediation.
Yes.
Hello. Hello.
Oh, hi.
Yes, good, thank you.
Oh, apologies. I'm not sure if someone needs to ask a question.
I think that was some kind of interference.
Okay, that's fine. I just thought I'd pause just in case.
Kate, we do have a question actually about mediation, and I don't know whether at this point might be a good time to ask, since we've been slightly disturbed. So Michelle has asked in the chat, can I ask about mediation? I have read the regs and understand that when parties don't agree on an attendee, the mediation company make the decision. My question is though, can the mediation company invite attendees? Parent doesn't want school to attend, LA didn't attend, request school attend, but mediator has invited the school against the parents' wishes. And the mediation was for refusal to issue.
A refusal to issue, okay. Well, I suppose it'd be quite useful to understand why the parent didn't want the school to attend. Presumably because maybe it wasn't going to be helpful to the parents' case, but where there's not agreement, the mediator does have the right to make the formal decision. I suppose the other point I would make is that attending mediation can be really helpful, but you only have to consider it. So if that parent feels that actually mediation isn't going to be a helpful forum to resolve issues, they might decide actually they just want to get their mediation certificate and go straight to appeal.
Yeah, that's quite common, isn't it, that some parents actually bypass mediation to get the certificate, and then others do mediation but still get the certificate.
Yeah, and it's complete. It's a total personal choice. So we get quite a few parents and carers call up our advice lines and ask, should I go to mediation? In fact, we are asked it so often. We have a section on our website, on our mediation page, that sets out some of the pros and cons. I think one of the things that's quite helpful when we think about mediation at the moment is the fact that hearings are taking up to are being listed for up to a year away. So mediation could be a useful thing to attend if you feel like some agreement might be reached. It might not be the whole challenge gets sorted, but it might be that some improvements could be made to an EHC plan, or maybe even if the local authority continue to refuse to carry out an EHC needs assessment, they might offer some extra funding, or for an EP, for example, to come and visit a school. So I think with mediation, it's a really personal decision, and it depends so much on your child or young person's circumstances as to whether you feel like it'd be of benefit to you. But there is quite a lot of information on our website about weighing up those pros and cons to mediation. That might be helpful to look at.
Thank you.
That's okay.
Kate.
Lovely. All right, so appealing. So once you've got your mediation certificate, or if you're appealing Section 8 only, you won't need it, then you need to make sure you get it to the SEND Tribunal within the deadlines I've set out here. I've also given you a link to the forms you will need. The Tribunal will make a decision looking at all the evidence that a parent, carer, or the young person and the local authority submits, and they will use that evidence and apply it to the law. So it's really important, if you're going to appeal, to get the evidence that you need. We've got some downloadable briefing packs on our website where I say get support here. You can access some of those briefing packs. If you are going to go to the SEND Tribunal, you can see some of the arguments that will be really useful for you to know of, as well as some important case law that can help you frame your legal argument. The local authority then has set timescales it must comply with if a tribunal orders it to do something. So you could find them in SEND Regulation 44. So for example, if the local authority is ordered by the SEND Tribunal to carry out an EHC needs assessment, then there are set deadlines that they must comply with following that. Okay, so to illustrate what we've been discussing, here are some examples. I think it's quite helpful when we're talking about legal concepts and principles to put them in practice. I think it can help sometimes make it a bit clearer. So, for example, if a local authority has refused to carry out an EHC needs assessment, then you'll need to consider mediation before going on to appeal in the SEND Tribunal if that didn't resolve matters. If a local authority has failed to meet its legal timescales for sending out a final version of an EHC plan, remember that 20-week long stop date we discussed earlier, or once it's issued, it doesn't get provision in place, then there isn't a right to appeal in the SEND Tribunal here. That wasn't one of those appealable decisions we talked about. You can use the complaints procedure, and you can make a decision about what route you might need to take next, depending on the circumstances. If a local authority has said it's going to stop maintaining a plan, that's that cease to maintain we talked about, then again, you'll have a right to appeal this in the SEND Tribunal, subject to considering mediation. It's really worth remembering at this point, a local authority can't stop the plan when they say they're going to on that decision. They've got to wait till either the deadline for you to appeal has passed, or the judge has decided that the plan does need to be stopped. So all the time an appeal is pending, then the plan will remain valid and must remain in place. If a parent carer has a need to make a claim for disability discrimination, this would happen in SEND Tribunal if it relates to a school of any type or a local authority controlled funded nursery. If you had a disability discrimination claim you needed to make related to a private nursery or further education or against a local authority, and this would need to be done in the county court, not the SEND Tribunal. And lastly, in these examples I just flagged here, if during the drafting stage of an EHC plan, the local authority refused to add in all the details you felt were necessary in sections B and F, which we see quite often, Then once the final plan is issued, you can appeal this in the SEND tribunal, subject again to thinking about mediation. Okay. So a little something to get us thinking about and give me pause for a breath. We're going to look at a few myths that we see. I'm going to give you some time to have a little think about the questions, and then we'll run through them in a minute. Okay. Does the local authority have to attend mediation? The local authority does have to attend mediation if you've requested it, and its representative must be able to make decisions. That's that SEND Regulation 37 we discussed earlier. The second one, the timescales to complain to the LGSCO and apply for judicial review are the same. No, they're quite different actually. Judicial review applications must be made within a maximum of 3 months, and LGSCO complaints can be submitted up to a year after the event. So quite different timescales there. Should you wait until the next annual review of your EHC plan to sort out issues? If you've got issues with an EHC plan, they can be dealt with at annual review, but this might be some time away. And we would always recommend, if you have a right of appeal, then you should use it. Lastly, is it expensive to appeal in the SEND tribunal? No, it need not be at all. Lots of the parents and carers that we advise don't use a solicitor to help them. And our advice line volunteers are trained to help anyone, any parent, carer or young person who needs them. So it need not cost you to appeal in the SEND tribunal. Okay, so we have looked at what the law currently says, and I'm just going to talk quite briefly about where we might be heading with the SEND review. I'm sure lots of you would have heard of it. Our policy manager is in regular meetings with ministers to explain the issues as we see them with the SEND review. And we understand a draft implementation plan, that's the government's response to the consultation, will be released soon. In the next few months, we've understood. IPSEA's viewpoint on the SEND review is simple. Many children and young people SEND don't receive the support that they need because the law is not applied, and there's no accountability for unlawful decisions. We think that rather than reforming the system again, we urge policymakers to ensure the last set of reforms, the Children and Families Act and the SEND regulations, are implemented so that every child has the opportunity to fulfill their potential. We don't see that the problem is children and young people SEND are receiving costly provision they don't need. We see that too many children are not receiving the support that they do need. We believe the current SEND framework is clear about what children and young people are entitled to and where responsibility lies. Much of the discretion that we see referred to in the SEND review is actually unlawful decision making. So here are 2 key issues we have with the SEND review, which I thought might be helpful to talk about in the context of this workshop. Firstly, we're concerned that rights are going to be diluted for a cost-saving approach. We mentioned earlier that parents and carers have the right to request a particular school is named in an EHC plan at the draft plan stage, and that local authorities must agree to this unless certain conditions apply. The SEND review proposes a pre-tailored list. What does this mean? Is if there's a school that you feel is suitable for your child but not on the list, will you be able to ask for it? Who's going to draw up these lists? Are they going to be in consultation with parents, carers, the people who know their children best? We also don't know what factors they will use to decide which schools go on the list. So it's a significant dilution of current rights. We're also concerned it's going to be far harder to enforce rights. We know that many families end up having to appeal unlawful decisions. Here, the review proposes to make all parents and carers attend mediation before they can appeal. There's already a requirement to consider mediation in all but Section I appeals, and those are quite rare. Section I appeals only are quite rare. So in most cases, parents and carers and young people already have to consider mediation. There might be very good reasons why a parent carer doesn't want to attend mediation due to their child's situation. Maybe your child is out of school or their mental health is really fragile and it's important to get the support in place now. Attending mediation will delay the point in which you can make your appeal. And as we know, wait times for hearings are already quite long. A few positive changes, though, that we would like to see from the SEND review is a national template for EHC plans. We also think the continuation of the extended powers of the SEND Tribunal. So currently they can make recommendations on the health and social care needs and provisions of children and young people. And we're glad to see that continuing. We would think that children and young people would benefit even more if those powers were strengthened so they could become binding orders rather than just recommendations. And lastly, the proposal to put SEND support in schools. So that's that provision of support that children and young people might require in school, but doesn't require an EHC plan. To put that on a statutory footing, we see as a positive. Bear in mind, though, the SEND review is not law yet. Your local authorities must be complying with the law as it currently stands, and not suggesting they don't need to due to any proposed changes. Okay, so that was the end of the presentation. We've now got time for some questions. I don't know, Sue, if there's some ones you want to pull out from the chat for me.
Yeah, hi. Sorry, I've not got my camera on. We've got a question from Catherine. She said, my son has ASD and ADHD. He's got high functioning, but struggles with social and emotional support and peer support. They told me because he doesn't struggle with learning, they won't give him an HCP. He is in year 10 mainstream.
Okay, so the Code of Practice makes quite clear that attainment in line with chronological age is not the only factor that we consider when we think about whether a child may have SEND. And that definition of SEND is really important. We talked about it at the very beginning. It's in section 20 of the Children and Families Act, because it helps us frame the argument as to whether an EHC needs assessment might be needed. So if you've had an EHC needs assessment request refused in the situation, Catherine, I'm not sure if you have, but if you have, then you have your right to appeal. You can find our downloadable briefing pack, which talks about those situations where local authorities say an EHC needs assessment is not necessary because we can't see lack of progress. But remember, in the Code of Practice, there are 4 broad areas of need, and these include social and emotional and mental health, sensory or physical needs that your child might have. It's not limited purely to academic progress. It might be that your child has academically maintained a good level of progress, but only because of significant support that's already in place, which isn't sustainable. Or it might be that their needs are not fully understood. So their progress could actually be much higher than it currently is. So it's what's expected of your child is also to be looked at. So I'd really recommend you have a look at that downloadable briefing pack on our website, because I think that will show you some of the arguments you can use to say why an EHC needs assessment may be necessary. Thank you very much.
I hope that answers your question, Catherine. We have a question from Roz. I heard that Tribunal cannot direct to EOTAS provision. What does this mean for an EHCP? LA are not answering any messages to find out about the annual review, amendment to plan, etc. And not all of the EOTAS support is in place, i.e. health provision is missing, yet this was the reason for moving to EOTAS.
Okay. I feel like there's quite a lot going on there, so I'm going to try and, if I haven't remembered all the points,
no,
I'll go through
one by one, yeah.
Highlight it to me. So in terms of EOTAS, that's because provision in a setting has been decided to be inappropriate. So in that case, your section F of your EHC plan should set out all the provision that's being that needs to be put in place. If provision in section F isn't being implemented, then you can complain to your local authority. If provision in section G, which is your health provision, is not being implemented, then you'd need to complain to your healthcare body. You said, so you mentioned annual review, yes?
Yeah. Yes, I said, no, I don't think it was about an annual review. Ros, is that answering your question? I said, I heard the Tribunal cannot direct EOTAS provision. What does this mean for an EHC?
Oh, Okay, so in terms of what the tribunal can direct, if the tribunal see that it would be inappropriate for any special educational provision to be delivered or made in a school setting, then the tribunal can order EOTAS. So in that situation, section I, which tells you the name of the setting the child's going to attend, that would be blank. It might be that the tribunal should consider that some special educational provision would be inappropriate in a school setting, in which case it might be the child attends a setting part-time, and the remainder of the time they would receive their provision either elsewhere or at home. And section F would detail all the provision, but section I would name a setting in that situation.
Yeah, and the last point Ros made was the health provision provision was missing. Yeah, that was the reason why it was.
If health provision is missing from an EHC plan, then that can be dealt with at the, well, I suppose the point is you don't, provision in a EHC plan relates to health has to be agreed by the health body. So if they don't agree to its inclusion in the plan, then it won't go in there. But the duty to provide that provision will still remain the same because it comes from the legislation. So if the duty has arisen due to healthcare legislation, then your healthcare body still has a duty to provide it, notwithstanding the fact that it's not in the EHC plan.
That's great, Ros. I hope that answers your question.
Not
Not
entirely.
entirely, okay.
I'll put something else in the chat.
It might be, Ros, that because you've got quite a lot going on, it would be really helpful if you booked an appointment with one of our advice line calls, and you can go through all the information you've got, all the facts, and one of our highly trained volunteers would be able to take you through all the different steps.
I will do that because
I'd
we
really
haven't even got
recommend
a drafted up change of plan. So
yeah, I'd really recommend you make use of that service.
okay, thanks.
Sounds like you've got lots going on. I'm sorry to hear.
I'm conscious we're probably not going to get through all the questions we've got, so I'll just whip through a few more. So Sarah's asked, if the tribunal orders the child's view from the LA and the child is non-verbal, who can provide these? And then a little bit later on she said this is under tribunal for section B, F and I.
So just so I'm really clear, Sarah, you're saying the tribunal's asking for the view of your child and the child's non-verbal. So how can you ascertain those children's views? Yeah, is that the question, Sue?
Sarah, yeah, Sarah, if you need to make that clearer, please just put your thing off on unmute yourself.
Yes, if I've
yes, sorry.
Yeah,
yes.
That's lovely. So in the case of a non-verbal child, there's lots of ways that potentially we could be seeking their views. So it could be that they could write it. Could they indicate it in a way? So if you
he's only 5.
Okay, but if you framed things as yes or no questions, and you in a way that's age appropriate, so you would know that your child would understand, would they be able to?
No, he has no understanding.
Okay.
Hence why we're going, and obviously the provision as well. It's unmet needs as well.
Okay, so if you're completely unable to ascertain in any way the child's view, then you've got to show you've done everything you can to get that view. But if you're not able to find any way at all to ascertain their view, then it might be that the parent's view will have to be taken into account of. Remember, your views as well as your child's views need to be thought of in section 19. So it's not just the child's view, the parent's view. Section 19 needs to also, local authorities need to have regard to their views as well.
So they sent in a specialist teacher from the local authority, went and done a observation the other day, because the deadline was today.
For the child's assessment, or for
the child's view, for the
child's view. Okay.
The order was sent from the tribunal, tribunal, okay, asking them to reply back with the child's view by the deadline of today. They went in on Friday to the school. The specialist teacher from the LA went into the school and done one and sent it in. And obviously I've seen it, but it's given a generalized view. It's saying like the child is happy to go into school, but from my parents' view, he's not happy because I get the breakdown in the morning.
Okay,
So
then I would suggest that would be useful information to submit alongside the observations, because we think about sometimes taking a picture of a child or a snapshot, if you like, but that doesn't always fully explain the situation. It doesn't give you context behind.
Yes, because they said they wanted they could have taken a picture of him, and I said, but a picture doesn't tell you anything.
No. So I would suggest in that situation, so it would be helpful to submit your own views alongside it. Yeah.
Okay. Sorry, I'm just digressing. Can I submit a response to their charge view that they sent over then?
Sorry, Sam. Not
so I can just respond to, obviously, that they've sent over the child's view. Can I just write a response in terms of my parents' view?
That's what I would do.
Okay.
That's what I would do.
Thanks. I'm just conscious of time. I think we're only going to probably have time for one more question, Kate. What would you like us to do with the other questions we have got?
I'll have a look through them, and if there's something like themes and things that I can pick out, I'll drop a note to Sarah, and then maybe when she sends the slides and the recording, I can put some responses there. I might not be able to go through absolutely everyone's, but
no, that's fine. There's not a huge amount afterwards. There's a quick one from Rashma. Can you advise what rights parents have to request an updated needs assessment during the AR process, where it's evident that the outcomes are not being met and the strategies need to be reevaluated?
Okay, thank you, Rashma. So remember, when an annual review process is being carried out, it's sometimes tempting to think about it in terms of the meeting, but actually the meeting is just part of it. So the bit before is an information gathering exercise, and the local authorities should be seeking information from health, social care, from parents, from school, for example, all around the child's needs, provision. And so that really can form part of a very useful annual review process if it's done properly. So at that point, if there's evidence to suggest that the child's needs have really changed, then that information should be gathered, and then it can be discussed at the meeting, because the meeting is really designed to consider whether the child or young person, what progress they're meeting towards their outcomes. And obviously, if their needs have changed significantly during that time, then that's going to form part of that discussion as to whether those outcomes remain appropriate, what progress they've made towards them. And then following the meeting is when the report gets written and a decision is made regarding the plan, which might be that it needs to be amended, which sounds like that would be a rational decision to come to, potentially in your child's situation.
Yeah. Thanks. Well, it's 11:30. I'm sorry that I didn't get to all the questions. There's some more, and thanks very much, Kate, for saying that you'll have a look at those, and we can put those on the website, Helen, I think, afterwards, just to give a response, if that's okay with you. So I'd like to thank Kate so much for coming today and taking us through that. It's been really useful and interesting.
All right, and thank you very much for all your excellent questions, as well as for attending today. It was a really pleasure to be with you all.
And just a reminder that IPSEA's website, and you can make appointments for one-to-ones and things, so people may wish to do that afterwards.
Lovely. Thanks so much.
Thank you.